Good afternoon, everyone.
Good afternoon.
Good afternoon, Judge.
Good afternoon, Your Honor.
Good afternoon.
Hi, Judge Mincy. How are you?
Hi, how are you, Mr. Walker?
I'm good. It's a pleasure as always.
Yes, haven't heard from you in a minute.
Good afternoon, Judge. How are you?
Good afternoon. How are you, Mr. Are you either? I'm getting some regulars that have come back today.
Almost every Wednesday, it seems.
Okay, right. Gotcha. All right, everyone, we're ready to start. Yes. All right. Good afternoon, everyone. I am Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar in which cases are brought for individuals who have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we're able to address several matters, including bond, possible arraignment, or plea offer if one has been made by the state at this juncture. And Ms. Bridgewater, what's our SAP reset date?
December the 20th.
All right, December 20th. And also, I want to begin by advising everyone that this entire proceeding is being recorded as well as live streamed on YouTube. Also, I want to inform the defendants and persons on this calendar that you do have certain constitutional rights. The first being that you have a constitutional right to have an attorney represent you at this proceeding, and you know who your attorneys are. So listen to them and govern yourselves according to what your attorney is advising you to do. I also want to remind you that you have a constitutional right to remain silent. So remember that anything that you state about the facts, the circumstances, or the occurrences in your case can and will be used against you. So I want you to make sure that you listen to your attorneys and don't make any statements that may be against your interest later down the road with your case. All right, deputies, who do we have first?
Good afternoon, Judge Mincy. In courtroom 2, we have a private attorney case. His client is position number 8, Mr. Gist, and we also have his parent in the gallery for him.
Okay, position 8. All right, this is Benjamin Sandoval. Is it Maya? And I apologize if I'm mispronouncing the name. Please forgive me. This is case number 22 CR 008072F. You're charged with 1 count of criminal trespass and damage to property.
Your Honor, I'm sorry. This is Mr. Duntrail Gist.
Position 8.
Number 8.
Hold on a second. Obviously, I have the wrong calendar. Sorry about that. Hold on. There we go. I think I opened the wrong calendar. One second. There we go. All right, hold on. Let me move this over. Okay, sorry about that. This is case number 22, CR 008161Y, Dontrell Gist. You're charged with one count of battery, family violence, and a second count of cruelty to the children in third degree, both with the offense date of September 27th, 2022. Am I on the right track?
Yes.
Yes, Your Honor.
Okay, thank you. All right, and you are represented by whom?
Attorney Charles Webb.
Attorney Charles Webb. Hi,
I
Attorney
just
Charles
getting back
Webb.
to the party.
Okay, all right. We'll have pre-trial to start first.
He has 5 cycles. His last arrest was from July. I'm sorry. I'm showing his last arrest listed as December 3rd of this year for fixing materials that reduce or increase light transmission of windshields. That was with Atlanta Police Department. However, I didn't see that case in Odyssey. He does appear to have an open case, 21 CR 005-581Y. It is for battery. I'm showing the victim as the same victim from this case today. He is on pretrial. He's out on pretrial in that case, so we're surrendering that bond. He also had a conviction from 2014. It was originally a DUI and it was amended to a non-fingerprintable charge. And he's a multi-state offender. He has 1 arrest out of Alabama from 2016 for possession of marijuana. There is no disposition listed and nothing further.
All right, thank you. And prosecution, ASG, is it Select?
Yes, Your Honor.
Hi, good morning, or good afternoon.
Good afternoon. On September 27th, 2022, at approximately 10:40 p.m., Officer Myro with the Atlanta Police was dispatched to 296 Northside Drive, Atlanta, in reference to the victim in this Miss Neshobe Huckleby, that's spelled Neshobe, last name Huckleby, Huckleby, being assaulted by the defendant, who is her child's father. Upon arrival, Officer Myro made contact with the victim. The officer described in his report immediately sensing fear coming from the victim based on her body language and the trembling of her voice. And Ms. Huckleby stated that she was also and wanted to inquire with him about housing resources for victims of domestic abuse. She began to go into depth about the assault that occurred earlier in the day. She stated around 11 a.m. on that day, she was getting her son, initials AG, who was 2 months old. She was getting him dressed when the defendant got upset about her choice of outfit for him. Ms. Huckleby went to go pick up their son from the defendant's arms, which led to him pushing her and striking her in the mouth with a closed fist. And this violence did occur in the presence of their 2-month-old son. The defendant immediately left the victim immediately left the residence at that time without her son, and she up her lip, her bloody lip, and took photos of her injuries. And she ended up calling the police later on that evening to report the incident. As stated, the defendant does have an open battery family violence case against the same victim, where, Your Honor, so graciously you ordered a signature bond allowing him to be out on pretrial services, and now he has picked up this new battery family violence charge against the same victim. The state would argue that he poses a risk of reoffending, and he has shown a history of violence as well. The defendant has also made phone calls to the victim while he's been in custody on this case. And there was a conversation where we did hear where he was trying to make her feel bad for reporting this case as well. So the state would argue that he poses the risk of influencing witnesses in this case. The state's recommendation at this time is going to be a $15,000 surety bond in total, $10,000 on the battery charge, and a $5,000 surety bond on the cruelty to children in the third degree. No contact with the victim, stay away from the incident location, no alcohol, drugs, or weapons. And the state is going to ask for a no contact with the child in this case as well. But if your honor is inclined to give third party transfer, we understand the discretion of the court. Nothing further at this time.
What are the initials of my minor child of the victim, the other victim?
That is going to be AG.
AG for the child. Okay.
Yes, your honor.
All right. And Mr. Webb?
Your Honor, my client is in fact the father of the child that's involved in this particular incident. We're asking the court to grant a $7,500 bond. I understand that this is involving allegedly the same victim. However, I'm unclear as to the incident location of this particular incident. My client lives at McDaniel Street in the city of Atlanta. But I understand that this particular incident was reported at Northside Drive. So when the solicitor is asking that my client not have any contact with the victim and my client lives together at that 369 McDaniel Street address in Atlanta. So we would ask that there be a no violent contact with the alleged victim in this case, and that the bond be set at $7,500.
And your honor, as far as the incident location, in your bond order from the 21 CR case, you did have in there that he was supposed to stay away from that McDaniel Street address. So he is not supposed to be at that address based on the previous bond order, your honor.
Okay.
Also, in addition to that, Your Honor, my client works, he's employed at Delta Airlines, has been there for 2 years. The child that's involved is 5 months old. He does take care of his dependents, and his mother is present here today in court to show support in this particular matter. My client graduated from Benjamin E. Mays High School in 2013. From their magnet program. He went to college at Valdosta State University, was a chemistry major there. We're asking the court to grant a bond in the amount of $7,500 in this case.
And I'm sorry, your honor, if I may, I apologize. I did state that the incident was reported at that Northside Drive address, but I state that the incident occurred at 369 McDaniel Street. So we would be asking that he stay away from that 369 McDaniel Street address as well.
All right. Mr. Webb, do you know if both parties' names are on the lease or ownership of the 369 McDaniel?
My client owns that particular apartment. She lives there with him along with the minor child. But my client is the person that's responsible for the payment of the lease.
Okay. And we don't have the victim on the Zoom line, do we at all?
Oh, I don't know. You can call for her, sound out for her.
All right, Miss Huckleby, is it Huckleby? Miss Shelby Huckleby? All right, I am going to go ahead and make my ruling. I'm going to grant a surety bond in the amount of $15,000. The first charge with the $10,000 on the battery, second charge on the cruelty, $5,000 for a total of $15,000 good bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order no further contact with the victim, Nishobi Huckleby, and no further contact with the victim, AG, who's a minor child. I think we need to make sure that they're going to be safe. Also, I'm going to order again a stay away from 369 McDaniel Street And what I usually do, Mr. Webb, is say that, and that's when I have evidence of that or testimony regarding the fact that possibly the victim or the victims, plural in this case, may be moving out from that location. And if the defendant has a law enforcement escort to return to that property with him, only with the law enforcement escort to make sure that they have moved, that there are no belongings there for the victim and the child, then he can reside there. Otherwise, he should not reside at that location. And there is a stay away from the 369 McDaniel unless law enforcement escorts him there and determines that the victim and the child no longer reside there.
Thank you, Your Honor.
Okay. Am I clear on that, Ms. Bridgewater? Just making sure.
That is correct. I have it.
Okay, thank you. Anything else, counsel, that I need to take up?
No, Your Honor, I just want to make sure I explain it to my client that he is not to return to that location unless he is escorted by law enforcement, and then law enforcement must make a determination as to whether or not the alleged victim and the child does not reside there. Only then will he be allowed to stay at that location.
That is perfect. Exactly. Thank you, Mr. Webb.
Thank you, Your Honor.
All right, thank you.
Good afternoon, Your Honor. This is the South Annex. Before you is position number 10, Ms. Lowe.
All right.
Your Honor, I would just like to inform the court that this position is a co-defendant position with position 11.
Okay, 10 and 11. Okay. Position 10 is 22 CR 008158B. Patrice Shantara Lowe, you're charged with 1 count of criminal trespass. That offense date is December the 6th, 2022. Pre-trial?
She has a total of 6 cycles. Her last arrest was October 13th, 2018 out of Clayton County for criminal trespass. That was a 2018 criminal trespass conviction. She has a 2015 criminal trespass conviction, a 2007 battery conviction, and then a 2001 battery, family violence, and criminal trespass conviction. She is recommended for a UJR through pretrial.
Okay.
Your Honor, in this incident that did occur yesterday on December 6, 2022, at the location of 764 South Grand Avenue in Atlanta, it is the premises of Gold Arc LLC. This defendant and the co-defendant in this case were found inside of that property, sleeping in one of the rooms with their personal belongings and a space heater. This home was actually being renovated, and the parties to this crime were discovered when the contractors came to that location to complete the work that they had been assigned by the owner of that facility. Given that, Your Honor, we do have some concern in this case about the risk of reoffense. This defendant does have 2 prior criminal trespass convictions, and I would also just like to note for the court that this defendant also has a current no further contact order with the co-defendant in this case due to a family violence matter that the co-defendant was sentenced on back in July of this year by Judge Law. Given that, Your Honor, there is currently a $2,500 surety bond preset on this case. The state is amenable to reducing that bond to a $1,500 surety. We're asking that there be no further contact between the co-defendants in this case. They're currently under a no further contact order anyway. We'd ask that they stay away from that location as stated on the record, have no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right, thank you. PD Kim?
Yes, Your Honor. Ms. Lowe is 41 years old, and she has been here in Georgia for all her life. Currently, she's residentially challenged right now. She has not been able to have any employment because of her disability, and she actually receives the disability checks, and she is qualified for public defender's service. So our office will continuously represent her. And she's residentially challenged. So it has been raining a lot lately, and she had to stay away to get some, to avoid the rain. We would like to request for signature on bond since she is qualified. I'm so sorry for my hiccup. I apologize. I don't know why it's not going away. I request for signature on bond since she's qualified. Thank you.
All right, I'm going to order the $1,500 signature bond through pretrial. And I'm going to order a stay away from 764 South Grand Avenue. I'm going to order no drugs, alcohol, or weapons while on bond. And I think that's it. Is there no further contact, I'm sorry, with the co-defendant in this case. I'm going to order that again and hope that there's compliance with the court's order, which is Eddie, is it Eddie Oglesby?
Yes, Your Honor.
No further contact with Mr. Oglesby. Anything else, counsel, that I need to take up?
Nothing from the defense, Your Honor.
Nothing from the state.
All right. That-
Position 11, Oglesby.
This is case number 22 CR 008160B. Eddie Oglesby, you're charged with 1 count of criminal trespass. Offense date is December the 6th, 2022. Pre-trial.
He has 49 cycles, 13 out of Georgia, 36 out of North Carolina. His last arrest was July 16th of this year for simple battery family violence out of Fulton County. He does appear to be on probation for that case. Case number is 22 CR 004-564Y, 12 months probation. The victim is the co-defendant. He has a 2013 probation violation, a 2011 robbery conviction out of Georgia. He has a 2019 common law robbery conviction out of North Carolina, a 2015 obtained property false tenants conviction out of North Carolina, a 2015 misdemeanor larceny conviction out of North Carolina, 2014 misdemeanor larceny conviction out of North Carolina. And then the next conviction is from 2000 for possession of a Schedule II controlled substance and habitual felon out of North Carolina. 1998 possession of a Schedule II.
I won't go that far.
Okay.
Yes.
Yes, Your Honor, as previously stated on the record, this offense did occur yesterday at the Golden Ark LLC property at 764 South Grand Avenue. The facts remain as stated on the record for position 10. In this case, Your Honor, the state does have some concern about the risk of reoffending and this defendant's likelihood to respond positively to the legal process as pretrial is stated. And I have previously stated on the record, this defendant has an extensive criminal history and is currently under a no further contact order with the co-defendant in this case. So therefore, he's currently violating the probation set by Judge Law in July of this year. Given this defendant's criminal history and the risk of reoffense present in this case, there is a $2,500 surety. The state is amenable to reducing that to a $2,000 surety. We believe that that's more than reasonable given this defendant's history and the current violation of the probation conditions set by Judge Law. We're also asking for no further contact again with the co-defendant in this case. Let's stay away from that incident location, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Good afternoon, Your Honor.
Good afternoon.
My client is 60 years old. He has been living in the state of Georgia, certainly for the past 20 years or so. He tells me that he is currently residentially challenged, doesn't have a place to stay. He also tells me that at the time of his last arrest, he had been employed, but because he was locked up, he lost his job, he lost his housing that he had. So essentially, he's living on the street. He told me that he needed shelter because it was raining very hard. That was the reason why he was at this particular property at the time. He told me it's a place that doesn't have any doors or anything, and he was just seeking shelter from the elements. My client does not have the resources to pay bond, Your Honor. I understand and acknowledge that he has a significant history. However, any kind of surety bond is essentially no bond for him. And I just want to bring that to the court's attention. I hope that my client can get some kind of assistance from social work, Your Honor, because he really is in a bad situation. And, you know, he's 60 years old, doesn't have education beyond the high school. As for his contact with the co-defendant, Your Honor, my understanding was that this was a term of his bond. I was unaware, and he certainly was unaware, that this is a condition of his probation. So it was not that he wanted to violate that, but that was his understanding, that that was a condition of his bond as opposed to a condition of any probation. So I would ask the court to take all these circumstances into consideration, the fact that he was merely trying to shelter from the elements. As we all know, it has been raining heavily and it has been very cold here in the past few days, and he just didn't have anywhere to go. Nothing further, Your Honor.
Okay.
And this,
Go ahead.
I'm sorry, Your Honor, this was in fact a condition of his probation to stay away from this co-defendant, in addition to some family violence intervention courses, along with some other conditions set by Judge Law. And she's usually pretty clear about her intentions when she makes these sentencing recommendation for these pleas. So we just want to make that clear for the record that we believe our recommendation, given all of the things stated and all the factors present, that we believe it's more than reasonable.
Okay. All right, I'm going to order the I'm going to order the reduction to $2,000 on the surety bond, $2,000 surety bond. I'm going to order again, stay away from the same location, which I believe is at 764 South Grand Avenue. No further contact with the co-defendant in this case. And no drugs, alcohol, or weapons while on bond. Anything else, counsel?
Nothing further, Your Honor.
Nothing further from the state.
Thank you.
Can I say something?
Don't think your attorney is going to advise or recommend that.
Mr. Oaksby, if this does not concern your bond, I would advise you not to say anything.
Okay, well, see, I just wanted, man, I don't have, how can I pay to get out of jail? If I can't pay to get out of jail, I can't pay to get no resources for no help. So I'm just falling right back in the same cracks of the sidewalk. I can understand what the public defender is, the lady is saying. Okay, so I can do that. But if I'm in jail, where's the help? Where's the help? So once I'm released, I'm still released back into the cracks of the sidewalk. So if y'all are not willing to help me help myself, then I'm going backward. And so is this law. I don't have no money. I don't have nowhere to stay because of the last incident in this same situation. But now that me and her has reconciled and have a child on the way, I'm not a threat to her. But if y'all want me to stay away from her, I can. But if I don't have no way to support that baby coming, then I'm a deadbeat father and I'm coming right back in front of her. And that's not right at all.
Mr. Oaksby, you can call me afterwards.
I do what now?
You can give me a call after court. The deputies have my telephone number.
What good is that gonna do, Miss McLean? What good is that gonna do if I can't make bond? If I
I'm
can't,
gonna try to see if I can get some help for you.
yes, ma'am. Yes, ma'am. Yes, ma'am.
All right.
Yes, ma'am.
Position 13, Stephen.
All right, this is 22 CR 008163H, Richard Stevens, charged with one count of fair evasion and a second charge of criminal trespass, both with the offense date of December the 6th, 2022. Pre-trial?
He has 50 cycles. Last arrest was November 30th of this year for criminal trespass out of Fulton County. He does appear to have an open case for theft by shoplifting out of DeKalb County, a second open case out of DeKalb for theft by shoplifting and willful obstruction of a law enforcement officer. He also appears to have an open case for theft by shoplifting out of Fulton County, 16 SC 146184. A fourth open case for possession of cocaine, affray, possession of marijuana, less than an ounce, and certain acts on bus, rail, or station prohibited. Case number 22 CP 205772. He appears to be on probation for theft by shoplifting. The disposition date was November of 2014. 2 years confinement, 8 years probation. A second probation with a sentencing date for theft by shoplifting with a sentencing date of July 2014. 24 months confinement, 8 years probation. A third probation for theft by shoplifting. Disposition date was June of 2014. 24 months confinement, 8 years probation. Another theft by shoplifting probation from October of 2014. 24 months confinement, 8 years probation. All of those probations are out of DeKalb County. As a 2018 conviction, sorry, that's one of the probations. As a probation violation from 2016 out of DeKalb County.
Okay. All right, is that it, pre-trial? I didn't mean to cut you off.
He has some more history. It's dated past the 10-year mark.
Okay.
And it's theft by shoplifting.
Okay. All right, thank you.
You're welcome.
ASGLS Duncan?
Yes, Your Honor, this incident did occur yesterday at the Lakewood MARTA station located at 2020 Lee Street Southwest in Atlanta. In this case, Your Honor, the defendant was observed by a plainclothes detail officer at that location, pushing through the fare gate without paying the recommended or required fee to gain entry into MARTA. When officers approached him and identified themselves as MARTA police, they asked for a valid ID. This defendant stated to officers that he did not have valid ID at that time. And at that time, he was handcuffed and escorted to the staff room for further processing. The MARTA police officers at that time ran the system, and it did come back to them that he had an active MARTA suspension that was effective October 28th, 2020, from October 28th, 2022, that became effective on November 27th, 2022, and was to resume on December 11th, 2022, and that this defendant did in fact have another pending suspension that was issued on November 21st, 2022 to take effect on December 11th, 2022, and to resume on February 19th, 2023. As a result of the multiple active and pending suspensions and prior suspensions from MARTA in 2016 and 2021, at that time, the defendant was issued a permanent ban from all MARTA property. Given this defendant's history, like I said, we do have some concern about the risk of reoffending, given that he's been criminally trespassed and suspended several times from MARTA services. We do have some concern about the likelihood to respond positively to the legal process, given this defendant's extended history. Given that, Your Honor, we're going to be requesting a $1,500 surety on the criminal trespass and a $250 surety on the fair evasion, making for a total of a $1,750 surety bond on both counts. We're gonna ask that the defendant stay away from all MARTA, as it is indicated that he now has a permanent ban from all MARTA facilities, that there be no alcohol, drugs, or weapons, and no further violations of Georgia law.
All right, PD Kim.
Yes, Your Honor. Mr. Richard Stephen is actually 47 years old, Your Honor. He was born and raised here in Georgia. He has one son who is 20 years old. He lost his parents recently, so he's grieving at this point, and he's been having odd jobs lately, about 2 weeks. But before that, he has not had any job. He has been employed long enough. He does not have any savings at this point. He graduated from high school. He is residentially challenged, so we would like to ask social worker services to provide housing resources for him. And that's why he has criminal trespass. We would like to request for a signature on bond for this case. And yet, if Your Honor is not inclined to give him a signature on bond, we would like to request for the minimum, possibly lowest possible bond, like $500 each charge and $1,000 good bond. He is qualified for public defender's service since he has no car, no house, no assets whatsoever. So he's financially challenged as well. Thank you.
All right. I'm going to order the 1,750 surety bond, with that breakdown being $1,500 on the first charge and $250 on the second charge, for a total of $1,750 surety bond. Gonna order no drugs, alcohol, or weapons while on bond. I'm going to order the stay away from that incident address. What was the stay away address?
Your Honor, the state is requesting to stay away from all MARTA since he has a permanent ban. However, the incident location was the Lakewood MARTA located at 2020 Lee Street Southwest in Atlanta.
Right, so there is a ban in place, and I hope that Mr. Stevens understands that that you're not to use MARTA. Gotta get the ride shares, Ubers, and other things like that. I'm going to continue with the stay away from the MARTA. And is there anything else I need to take up with this case?
Nothing further from the state.
All right, that concludes this matter.
Thank you.
Mhm.
Position 14, Sweeney.
All right, this is Xavier Sweeney. Case number 22 CR 008165H. You're charged with 2 counts of cruelty to children in the 3rd degree, 1 count of battery, family violence. The offense date is October 13th, 2022. Pre-trial.
He has 12 cycles. His last arrest was December 3rd of 2022 out of Douglas County. The purchase, possession, manufacture, distribution, or sale of marijuana. That appears to be an open case. He has a August of this year conviction for driving while license suspended or revoked. a probation violation from 2010. That was the last probation violation. One FTA, another probation violation from 2009, FTA from 2006, a possession of a controlled substance and fleeing or attempting to elude a police officer conviction from 2006, another FTA from 2006, and then a willful obstruction of a law enforcement officer, along with a possession, manufacture, deliver, distribution, or sale of a counterfeit substance conviction from 2006. Nothing further. He did have a battery arrest from December of 2017 with Atlanta Police Department, but I didn't see a disposition on the GCSE. And nothing further.
All right. ASGLS Duncan.
Yes, Your Honor, that 2017 battery arrest was null pros. However, it did indicate that it was that same victim in this case. Your Honor, this incident did occur on October 13th, 2022 at 3790 Benjamin Court. The victim in this case, well, the victims in this case, first being Courtney Sweeney, that's Courtney, last name Sweeney, Swinney. And there are two minor victims in this case as well, initials ZS and initial CS. This incident did occur at the incident location as stated on the record. It's indicated from the police report that they were arguing on that day, particularly about rent money, and that the defendant became irate and so upset that he punched a hole in the wall because the victim in this case had stated that she had not paid him. Once he punched a hole in the wall close to their bedroom, the victim stated to officers that he became even more irate and struck her in the face with a closed fist, causing a large laceration on the left side of her cheek, which officers were able to observe. They also observed that laceration on her face was bleeding, and they did also observe two broken fingernails and blood on Miss Sweeney's clothing. Officers stated at that time that they were told that the defendant had left shortly before they arrived. She stated that that the defendant in this case did not have a key to the residence, but he did have a garage door opener. So at that time, officers assisted the victim in this case with disabling the garage to attempt to keep the defendant out of the home for the night. She stated to officers at that time that she was going to be beginning the eviction process. Your Honor, and it is indicated that the two minors, as indicated earlier, did witness these events. We have some concern about the risk of reoffense given that 2017 battery arrest. We have some concern about the particular danger to this victim, to all of the victims involved in this case. Our office did attempt to make contact with the contact information that was provided in the documentation. However, it was indicated that that number was not in service, so we were not able to make contact. Our recommendation is based out of an abundance of caution. We're going to be requesting $1,500 for each of the cruelty to children in the third degree counts and $5,000 on the battery family violence, making for a total of an $8,000 surety in this case, Your Honor. We're asking for no further contact with any of the victims involved in this case. However, we understand that we will defer to the court on that issue. We're asking for a stay away from that incident location, 1 day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Your Honor, my client is 35 years old. He and the alleged victim are married and they share two minor children. My client tells me that on the date this incident allegedly happened, only one of the children were at the house. My client no longer lives at that location, Your Honor. He now lives in another county. He lives in Douglas County and has been living in Douglas County for the past 2 months. He tells me that he still sees the children quite frequently, at least once a week. I was able to speak to the alleged victim, Your Honor, and I believe she's on the Zoom. She told me that she does want my client to have contact with the children. My client tells me he's been seeing them regularly anyway, and she told me that she is not afraid of my client at all. My client does have gainful employment, Your Honor. He tells me that he operates a barbecue business. I would ask the court to consider these factors in setting a bond for him. As the parties are married, my client does have a legal right to see these children. And he tells me that the alleged victim has been facilitating that so far. And I would ask the court not to prevent that, because it is important for children to have contact with their parents. And since the alleged victim obviously has no issue with the children interacting with their father, that the court should not put any orders in place which would prevent him from exercising his right to see these children. I would ask the court to set a reasonable bond for him. I do acknowledge that he has some history, Your Honor, but it is not extensive. The last time he was arrested, as the prosecution said, it was null pros, the case was null pros. I would ask the court to sound for the alleged victim as well, so that she can explain how she feels about my client to the court.
And just to be clear, Your Honor, that battery arrest was in 2017. However, the defendant has been arrested since then in Douglas with a possible open case. And while the state understands the defense's contentions about this defendant's legal right to see the children, however, the state does have an extreme concern when those children are allowed to witness acts such as the one alleged here, where their mother is battered to the point she's bleeding. So we believe our recommendation is more than reasonable. I do see Ms. Sweeney on the line, if Your Honor would like to sound for her at this time.
All right. Is it Courtney Sweeney?
Yes, ma'am. I'm here.
Yes. Would you like to address the court today regarding your case, Ms. Sweeney?
I mean, as the lawyer was saying, me and Mr. Sweeney, we've been in a relationship for the last
Hold on.
8 years.
Hold on. That was first a yes or no question. Would you like to address the court today?
Yes, I would like to. Yes, ma'am.
Okay, then I'm going to need to see your face, and swear you in. Can't talk to you behind a picture.
Yes, ma'am.
Okay. All right. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay. And now you can start telling me what you want me to hear.
Me and Mr. Sweeney, we've been together for 8 years. We have 2 kids together. We just was going through a bad time. We haven't really had many domestic situations other than the prior one in 2017. We have, since that day, he has moved out. We are not living together. We have came to agreement to where we have mutually been able to communicate with the kids with no issues. He's a great father. He takes care of them. We haven't had any arguments since we moved out. We agreed to, not to get together anymore because of the issues we was having. So I never, after this incident happened, after I spoke to the detective, I told him specifically that I did not want to pursue the situation any further because of the fact that it had been so long since they reached out to me about the situation and we was no longer living together. So with that being said, because we do work together and we have kids together, I want him to be able to come around our kids, especially with the holidays coming up and stuff like that. So I never wanted to pursue the charges, but the detective went ahead and did so anyway.
Okay.
Your Honor, if I may just ask a couple questions.
Yes.
On October 13th, Mrs. Sweeney, did the defendant in this case strike you in your face, causing laceration and bleeding?
Okay, so it wasn't an open fist. He actually just scratched me in my face. It wasn't like an open fist to where he like openly punched me. We were arguing. We was, going back and forth. It wasn't a situation like we didn't tussle with each other. It was an active fight between me and him both.
Okay. Were any of your children present during this incident?
My daughter was.
Okay. And that night, did you ask the police to help you lock the garage so he couldn't come back?
Yes, because we had already had agreement he was gonna move out, which he did. He did move out with no incident, without the police coming back. He came and got all his stuff the next day, and we have not had an issue since.
Thank you for that, Your Honor. The state believes this recommendation is more than reasonable, given the other factors present in this case and the cycles of violence, as Your Honor is very well aware. Nothing further from the state. We'll be requesting that $8,000 surety.
Your Honor, I would ask for a more reasonable bond for my client. Mrs. Sweeney has stated that my client moved out of the house after the altercation. He moved out peacefully without the police having been required to come back. This happened over 2 months ago. They have been living separately. They have been co-parenting, and all is going well. I would ask the court to not impose any conditions on him seeing his children, and also that the court to give him a reasonable bond. Nothing further, Your Honor.
Okay. Hold on 1 second. All right, on this case, I'm going to grant the $8,000 surety bond. And that breakdown is $1,500 on the first charge, $1,500 on the second charge, and then is it 5,000 on the third? It's my math. Yeah.
I'm sorry, Your Honor, just to clarify, they're kind of out of order. So the first cruelty to children is count 1. The second cruelty to children is count 3, and the battery family violence is in the middle.
Oh, you're out of order. Okay, so I'm sorry.
Yes,
On the
and
first, yes, on the
I'm
first.
sorry, Your Honor.
I'm sorry.
But the alleged victim's testimony was that there was only one child there, and that was also what my client said.
And Your Honor, while we understand defense's contentions, at the time of this incident, the victim did report that both of the children were there and witnessed this incident.
We'll have to sort out the charges later, or depending on what the state gets any more information to dismiss one of the cruelty charges. But right now, in order for the bond issues, I'm sorry, to be $1,500 on the first charge, $5,000 on the second charge, which is the battery, and then the $1,500 on the other cruelty. So $1,500 on each of the cruelty charges, and then $5,000 on the battery. Is that clear, Miss Bridgewater? For a total of $8,000 surety bond. I'm going to order a stay away from the incident locations at 3190 Benjamin Court. And I'm going to order no further contact with the victim, Courtney Sweeney, and the 2 minor children, whatever their initials are.
The initials are ZS and CS.
Okay, DS and CS. And I don't know, does the defendant need a one-time escort to the property to retrieve any personal items?
I think
He doesn't live there, Your Honor.
doesn't live there. I guess he does.
Your Honor, he does not live there anymore. He moved out the day that the incident happened. And as I stated before, like my kids are actively with their dad. Like he picks them up from school. He's with them every weekend. We work together. So that'll be very hard for him not to have contact with them or contact with me.
Well, we had an incident that, I guess the incident was back in October, so October 13th.
Yes, Your Honor, the state would recommend that in this case, they set up some type of visitation schedule. If the children are children of the marriage, then that could be established through a superior court, some type of visitation order. But given their circumstances, and this is not the first incident of violence between the parties, we think it would be reasonable under these circumstances.
And Miss Sweeney, you're married to the defendant?
We are.
Okay. And these are his biological children?
They are.
And so sometimes I order visitation through a third party so
It's
that
not necessary because he's
hold
not
on,
gonna harm
Miss
them.
Sweeney. Miss Sweeney, you won't cut me off. You won't allow that. And so what's necessary is that everybody's safe. And that is my responsibility to make sure that you're safe and that these minor children are safe who can't take care of themselves. How old are the children, Miss Sweeney?
7 and 3.
Oh, 7 and 3. They're very small children. And so my responsibility is to make sure that they're safe, that they don't witness any more violence, and that they're not subject to any violence or any actions against them. And so I know that this happened in October, and I understand that you're telling me Mr. Sweeney picks them up from school and things of that nature, but there are 2 cruelty to children charges pending against him. You understand that?
Yes, ma'am, I understand that, and it shouldn't have happened because, as I stated before, he has never harmed his kids. He's a great father to his kids, and just like anybody else that go through relationship problems, that's just one of the situations. We had a bread running, and that's why we agreed to separate, and we have not had any issues since. So,
well, that's because you both live in separate residences, right? And so are you at the 30, who's at the 3790 Benjamin Court?
I am, me and the kids are.
Okay, so he won't have a problem staying away from there. The issue is, and I know that you may need help with them, but I want to make sure, not harming the children, but allegedly harming the mother or having an incident in front of the children. That is what we're trying to make sure, that there's been the ample sufficient time for cooling down, as well as the defendant understanding that those type of things do affect the children and cannot happen in front of the children, shouldn't happen at all. I know there are allegations at this point, but I do want to make sure that Mr. Sweeney understands he may be an excellent father, but also being an excellent father is respecting the mother. So that goes hand in hand. And I guess my other question is if there's someone else that can do the pick up and drop off of schooling, some other third party that can do it besides Mr. Sweeney.
No, ma'am. His mother is on disability, and my mother actually works a full-time job, so we have to do it together. It just what works best for us. Mr. Sweeney have 3 other kids, so it's not an issue of me feeling like it'll be a problem with him being there physically for his kids.
Does the state have any objection to Mr. Sweeney being around his children?
We'll defer to the court.
I have a problem with it, Ms. Sweeney, but I'm trying to not make your life more difficult. But sometimes these situations can make it difficult. And they're 7 and 3. The 3-year-old is not in school, just a 7-year-old.
They both in school.
Okay, 3-year-olds in pre-K or something?
Yes, ma'am.
Okay. And normally I don't allow the defendants, depending access to the victims in my case. Because you are here and you're telling me that you feel like your children will be safe if Mr. Sweeney's around them or picks them up, is that your testimony?
Yes, ma'am. I mean, I need his help. Like, I have 2 younger kids and I'm trying to run a business, so it's really hard enough not having him here physically in the house.
Okay. Well, I'm going to order the stay away, so he has to stay away from that location. He cannot reside there or come back there. But I will allow him limited access to the children, Ms. Bridgewater, just to pick them up and drop off from school. Any other visitation or access needs to be restricted at this time. So I will just allow Mr. Sweeney to pick up and drop off access with the children.
Your Honor, he does already have visitation rights with my daughter every other weekend. was just already court ordered, so I don't, are you taking that away as
Which
well?
child is that? Which child is that? The 7 or the 3?
7-year-old.
So you already have an order for visitation through the Superior Court?
Yes, ma'am.
You're going through a divorce?
Yes, ma'am.
And that's a temporary order from Superior Court?
Yes, ma'am.
And the state would renew its contention that this visitation issue can be further solved by the Superior Court and an addendum to that custody order, and for the time being, no further contact. We understand what the victim is stating. However, given the concerns shared by the court and the state, we think that it's reasonable right now for there to be no contact, given the nature of the alleged offenses. And since there's already an open case, they can go through the process to add the other child since there's been continued violence.
Your Honor, the victim has testified that she's not in the least bit concerned about the safety of the children around my client. They're 3 and 7 years old. He is their father, and she, as their mom, knows how she feels about him. She's testified that he's a very good father, that he loves his children and takes good care of them.
And
What's the date, Ms. Sweeney, of their order from Superior Court?
I'm sorry.
What is the date, or when did you get your order from Superior Court with a visitation schedule?
This order was, I want to say in April 2018.
April of 2018? Your
Yes,
divorce
ma'am.
has been pending since 2018?
Yes, ma'am.
Well, unless you go back with Superior Court to get some type of amended order, something that sounds a little odd to me. I'm not sure why. As ASG Duncan has stated, I'm going to defer to either the limited contact, the pick up and drop off from school, or none whatsoever. Because it's a little difficult to have him to come around them if he shouldn't, because of this case that was that came subsequent to your Superior Court order.
And I think it would be in the children's best interest to have contact with their father. And ultimately, the best interest of the children trumps everything.
And this Superior Court order was after the first incident of battery against this same victim, Your Honor. And we are.
I understand, but how is mom to explain to these young children that they can't see their dad even around Christmas time? He can't bring them presents. He can't do anything. They're only 3 and 7.
Right, I understand, but we do have family violence going on here. So she's got to explain that to them as well. And that can be difficult. It's going to be a hard conversation. But I also want to make sure that everyone's going to be safe, even around Christmas. He can send the gifts over through someone else. I do understand the concerns. That Superior Court order is old to some extent because it was after the first one in 2018, and we've had a subsequent incident, and that alarms me. So what I'm going to do again is to state, Ms. Bridgewater, that there would just be limited access for pickup and drop off from school, but no other visitation with the father other than that. And again, no further contact with the victim, the mother in this case, and then to stay away from the incident location unless there is a Superior Court order that that court determines would be in the children's best interest to have additional contact with them other than my limited contact. Is everybody clear on what I've ordered?
Yes.
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. Good luck to you, Ms. Sweeney.
Thank you, Your Honor.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, you may. Thank you. Have a good afternoon.
You too, Your Honor.
Okay,
Thank you.
thank you.
Position 4, Denomis.
All right, this is case number 22 CR 00815 F. It's like Anthony Denomus Hood is what I have. There's one count of battery family violence and a second count of cruelty to children in third degree, both with the offense date of December the 6th, 2022. Pre-trial.
6 cycles. Last arrest was on October 10, 2018, out of Wisconsin for operating after suspension warrant. I'm showing 3 misdemeanor convictions, all out of Wisconsin. 2019 disorderly conduct, 2011 battery, and then 2009 disorderly conduct. Nothing further.
All right. This is ASG. Oh, select. I'm sorry. Go ahead.
Yes, Your Honor. On December 6, 2022, College Park police officers were dispatched to 4864 Embarcadero Lane, and that's spelled EMBARCADERO, apartment 31-4, College Park. Upon arrival, officers spoke with the victim in this case, Kamoria Crittenden, and that Kamoria is spelled Kymoria. Crittenden is spelled Crittendon. Ms. Kamoria stated that the defendant came home from work and poured himself a cup of soda. The defendant heard laughing. He accused Kamoria's sister of laughing at him, but Ms. Kamoria informed the defendant that she was the one who was actually laughing at him. This angered the defendant, and he began yelling at the victim and threw his drink at her. Ms. Kamoria then threw a tablet at the defendant, and at that time, the defendant shoved Ms. Kamoria, and at that time, she was fearful and grabbed a knife in order to defend herself from the defendant. The defendant began to wrestle with the victim over the knife and in an effort to get the knife away from her. And during that wrestling or tussling, the victim did receive visible injuries. She had marks on her hand and on her elbow. The victim's 11-year-old sister was present as well and witnessed the incident. Her initials are CDH, and the defendant in this case is Ms. Kamoria's mother's fiance. So they do all live at that incident location. And we did have contact with the victim, and she did state that she is in fear of the defendant and would not like him to return back to the home where they all reside. What pretrial stated as far as his history is correct. I have a previous 2011 battery domestic abuse conviction out of Milwaukee County. One of those disorderly conducts was initially, he was arrested for battery and it was amended to disorderly conduct. So due to him having a violent arrest and conviction history, and now he has picked up another family violence charge as well, the state is requesting a $6,000 surety bond in total, $5,000 surety bond for the battery family violence charge, and $1,000 surety bond for the cruelty to children in the third degree charge. No contact with the victims in this case, stay away from the incident location, no alcohol, drugs, or weapons, and 1-day anger awareness. Nothing further from the state at this time.
All right.
Yes, Your Honor. That's my case. I have spoken with Mr. Denomus Hood. He does have the 2 charges, the battery and cruelty to children. He does dispute the allegation that he was the primary aggressor, Your Honor. My client's position is that there was a verbal argument about doing chores, and the alleged victim, who he described as his stepdaughter, the daughter of his fiance, he indicated to me that she attacked him first, threw the tablet at him. He was trying to control her physically just with his hands, and she got the knife, which his position is that that's just escalating. She escalated the situation physically and to the point of threatening him with a lethal weapon, and using his hands to take that from her hand would certainly in our position be justifiable, given that it would be a self-defense situation. But that is our position on that. He is employed full-time. I'm advised that he's a banker with Wells Fargo, and they do live in the same household. I did advise him that the court may take the position that there would be a no further contact order, although he is asking for no further violent contact. He is asking for a signature bond, Your Honor, given the allegations and his position in this case. The fact that he's employed, he has ties to the community, he has relatives that live in the area. If the court is not inclined to grant a signature bond, we would ask for a $2,500 bond on the battery and $1,500 on the cruelty to children.
And Your Honor, I do see Ms. Crittenden on the line, if Your Honor would sound for her when Your Honor feels it is appropriate.
Okay.
And I would also say, Your Honor, the one thing I wanted to add, my client indicated to me that he was the one that called the police.
Okay. All right, Ms. Crittenden. Can you hear me?
Yes.
Yes. Would you like to address the court today?
Yes.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury? All right, go ahead and tell me what you'd like me to hear about this case.
I feel like the situation, I wasn't the aggressor because on the simple fact that I didn't do nothing but defend myself. Like the police that he threw his drink at me, and the police filled my shirt, seen that the drink was threw at me when he seen it on the wall.
Okay. Let me ask you this. Now, this is not a trial, and I'm not here to weigh heavily on the facts, except that I want to know about whether you are in fear of Mr. Demone's Hood or Denoma's Hood. Tell me that. Are you in
Yes,
fear of him?
yes, and no, no.
Say that again. I'm sorry.
Yes, no, but I'm taking the urge to move out and go stay somewhere else.
Mm-hmm.
The case is over or wherever it's gonna happen.
Okay. And do you have children with him?
No.
Okay. And so you're planning on moving out?
Yes.
Okay. Is it soon or a couple of weeks or a month?
Soon.
Soon. Okay. All right. So you don't want to be residing with him?
No.
Okay. And you don't want any contact with him, is that correct?
Well, I gotta have contact with him because my mother is here. So I don't.
Oh, you're moving out, but your mother is going to stay there to reside with him?
Yes.
Well, that's it. If I don't order him to stay away from there, right?
Yeah.
Who's is this is an apartment. Whose name is on the lease to the apartment?
I don't know. I don't know.
Who lived there first, your mother or him?
We all moved in at the same time.
All moved in together? Okay, at the same time. All right. And your mother wants to stay there?
Yes.
You think your mother's in fear of him?
No.
Are you in fear for your mother's safety if she's there with him?
No.
Okay. All right, any cross-examination of the witness by either attorney?
None from defense, Your Honor.
Nothing from the state, Your Honor. No other questions. I just wanted to reinstate our request for no contact and stay away from the incident location. This incident did just occur on yesterday. And at this time, I don't believe that, based on the testimony, we're for sure when Ms. Crittenden would be moving out. And so I would ask that at this time, there would be a stay away, and in the future, if the defense would like to file a motion to modify, then that would be appropriate. Nothing further from the state at this time.
Well,
Yes.
well, Your Honor, we would ask the court to consider if Ms. Crittenden is planning to move out, a no further contact order, but with the provision that if she is no longer staying at the household, that he can go back there.
Okay. And I'm assuming, just making sure here, the mother is not listed as a victim in this case?
No, Your Honor, that's correct.
I don't see anything indicating she is.
Okay. All right, so I'm going to order the $6,000 surety bond, $5,000 on the battery, $1,000 on the cruelty. I'm going to order that the defendant is to stay away from this location, that he's to have no further contact with the victim, Moria Crittenden. So that I want to make sure that he's not residing at this location. And it sounds like he has the resources and the means to find another place to live. And
I had discussed with him a possible need to do that.
okay, good. And so that making sure that if the victim goes to visit her mother, that she would not be subjecting herself to any additional incidents, and there wouldn't be any violations of the bond conditions. So he should reside somewhere else. I'm not going to order that, law enforcement go back to determine the victim, because the victim and the mother, that's a pretty close relationship. So he just needs to stay away while he's on bond. And
would he be able to go back?
I'll order a one-time law enforcement escort to that property to get any personal belongings. I'll do that. No drugs, alcohol, or weapons while on bond. And I won't order the anger awareness course yet. I won't do that at this point. And I think that should be all. All right, that's the ruling of the court.
Position 5, Dodge.
Yeah, you are.
All right. This is case number 21 CR 008155A, Michael Dodds. You're charged with 1 count of willful obstruction of a law enforcement officer. That offense date is December the 6th, 2022. Pre-trial?
He has a total of 33 cycles. Last arrest was October 8th, 2020 for probation violation. He appears to be on probation out of Clayton County for criminal attempt to commit a felony. Disposition was February 21st, 2018, 5 years probation. Also appears to be on a second probation out of Fulton County for robbery by force, burglary in the second degree, criminal trespass. Case number 18 SC 161069. Disposition was October of 2018, 1 year confinement, 4 years probation. He has a 2019, 20, and 18 probation violation. Has a theft by shoplifting conviction from 2017 out of Fulton County. A 2015 conviction for criminal attempt to commit a misdemeanor out of DeKalb County. A 2010 theft by shoplifting conviction. A 2010 driving while license suspended or revoked conviction. 2007 criminal trespass conviction. 2003 burglary. 2005 burglary conviction. And nothing further to add. Oh, I'm sorry, he also had a 2020 theft by shoplifting conviction.
Okay.
And nothing further.
All right, ASG Select.
Yes, Your Honor. On December 6, 2022, officers received an anonymous tip from a concerned citizen that they had witnessed a suspect, the defendant, who they believe had stole copper from a Kroger at 2685 Metropolitan Parkway in Atlanta. That witness stated that they believe they saw him on Parnell Avenue in Atlanta. The tip stated that the defendant was a male with a bald head, riding a bike, and had a grocery cart of copper. Officer Watson arrived at 410 Connell Avenue in Atlanta, Georgia, around 1:47 p.m. on December 6th, and saw that male fitting that description. And he witnessed the cart in a white truck. He witnessed that man standing by the cart, and it was full of copper. Officer Watson advised the defendant why he was speaking with him and asked if he could write down his name and date of birth on a piece of paper. The accused wrote his name down and date of birth, and officers ran that through GCIC, and he returned with an active warrant out of East Point. And as the officers were placing him under arrest, he fled. Well, as they attempted to place him under arrest, he fled on foot into the woods. Officers had to deploy the city-used taser at the back of the defendant, and he was able to pull the wires out and continue to flee. Canine dogs had to be requested, and they were eventually able to locate the defendant in the wood line, and he was arrested at that time. The defendant has 34 arrest cycles since 1998. I heard several different theft convictions. So the state would argue that he does pose a risk of reoffending while out on bond. He's currently on felony probation and has continued to pick up new charges. The state would argue that he is a danger to the community and the property of others with his previous theft convictions. The state also saw a 2017 arrest for FTA, so we would argue that he does pose a risk of not appearing for court in the future. So at this time, the state would be requesting a $2,000 surety bond and no alcohol, drugs, or weapons while out on bond. Nothing further from the state at this time.
All right, PD Bartels.
Yes, Your Honor. I did speak with Mr. Dodds about this case and about his situation. He is 46 years old, has lived in the Atlanta area all of his life, I'm told. His mother, aunts and uncles and sisters all live in this area, so he does have ties to the community. He advised me that he thought there was an error with this warrant because he did enter a guilty plea to the same charge in Fulton County several years ago. And he was concerned, was trying to talk to the officer that this warrant was actually for a case he already entered a guilty plea to. I have not been able to sort that out yet. I'm still looking into it. But it is the same charge, but I can't find a warrant number in the old case, the 2018 case. So I will continue to follow up with that. But I advised him that, East Point will have to look into that. There's a hold for that charge. But given all that, we would ask that the court set a $1,000 bond in this case.
All right. I'm going to order the $2,000 surety bond. No drugs, alcohol, or weapons while on bond. Stay away from the incident location, which is 2685 Metropolitan Parkway.
Okay, and Mr. Dobbs, I will continue to look into that situation with East Point. Okay?
That should conclude this matter.
Position 1, Brown.
Thank you, Your Honor.
Okay, thank you. This is case number 22 CR 008152G. Darren Brown, you're charged with 1 count of battery family violence, 2nd count of battery against a female who's pregnant. The offense date is 9/26/2022. Pre-trial.
Yes, 13 cycles. Last arrest was September 15th of this year for driving while license suspended or revoked. He does appear to have an open case out of Cobb County for possession of a firearm by a convicted felon, driving while license suspended, and giving false name, address, or birthday to a law enforcement officer. Appears to have an open case out of Fulton County, 17 SC 150496. That is for possession of tools for the commission of a crime, 2 counts of entering auto, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, driving without a valid license. He appears to have 2 other open cases for driving while license suspended or revoked. He appears to be on probation out of Clayton County for possession of a firearm by a convicted felon or felony first offender. Disposition date was March 21st of this year, 5 years probation. He has a 2014 FTA. I counted 4 probation violations, 2022, 2020, 2017, and 2016. Has a simple battery and driving without a valid license conviction from Fayette County from 2017. A 2015 conviction for robbery out of Douglas County. And nothing further to add.
Okay. ASG Select.
Honor, on September 26, 2022, Officer Kelly responded to 3787 Martin Luther King Jr. Drive in Atlanta for a dispute call. Officers spoke with the victim in this case, Miss Rodnisha Frison, spelled Rodnesha Frison, Frison. And she stated that her boyfriend at the time, the defendant, and her were arguing, and he punched her in the face and then pinned her down. There was visible injury to her lip and blood on her shirt as well. Ms. Frison stated that she and the defendant had been living at that location, which is her mother's address at the time because she was pregnant. Officer Kelly also spoke with the victim's mother, Tiangela Frison, spelled Tiangela Frison, and she stated that she was present when the incident happened. She stated that she heard her daughter say, "Get off of me," while they were in another room. And then when she walked back into that room where they were, she witnessed the defendant on top of her daughter. The defendant then left the home out of the back door at that time, so he was not present when officers arrived. The defendant does have a 2017 simple battery County that is with a different victim. And we also noticed a 2014 FTA arrest as well. Due to the defendant having at least 14 arrests since 2010, the state would argue that he does pose a risk of reoffending in the future. He has a previous violent 2017, and also just due to the facts of this case, this victim being pregnant at the time when this battery took place, the state would be asking for a $10,000 bond in total, $5,000 surety bond on each charge, no contact with the victim and the witness, the victim's mother, stay away from the incident location, no alcohol, drugs, or weapons while out on bond. Nothing further from the state at this time.
All right, and what's the incident location, the address for the stay away?
That is 3787 Martin Luther King Jr. Drive, and that's apartment B2 in Atlanta.
All right. Mr. Bartels?
Yes, Your Honor. I have spoken with Mr. Brown. I have also spoken with Ms. Eisen. I believe she is on the call.
You're going in and out on me.
Hear me now?
Yes, now I can hear you.
Yes, I did speak with Mr. Brown, Your Honor. I also spoke with Ms. Friesen, who's listed as the complaining witness. I know that she was on the call earlier. I don't know if she is still there, but or if she wants to address the court. But my client, he wants the court to know he actually was pulled over in DeKalb County on Friday pursuant to this warrant. So he's been incarcerated in one place or another ever since Friday, December 2nd. He indicates that he is employed full-time. He works at a manufacturing company. He does have family in the area. He indicates his father, brother, and aunts and uncles all live in the metro Atlanta area. And he does understand that there may be a no further contact order, so that he says that they're not living together now regularly. He has another place where he can go. But he is employed full-time. He does have ties to the community. And I did speak with Ms. Friesen. I do not believe that she had indicated she wasn't in fear of her safety. She indicated that she was trying to tell the police officers that he did not hit her, but she indicated the officers who responded, she characterized it as not really wanting to hear her side of the story. So again, if she can address the court, I know that that would be a possibility. So given all of that, excuse me, I'm recuperating from a cold. My voice is still letting me down sometime. But one of the charges, I think the battery would be, should be a lesser included offense. It's based on the same alleged act. So we would ask for a $2,500 good bond on one of the charges and a signature bond on the other charge, based on them both being the same unit of prosecution.
All right, is it Friesen? Rodney Schiff, is it Friesen or Friesen?
It's Friesen.
Friesen, okay. Sorry about that. Do you wish to address the court today?
I'm sorry, I couldn't hear you.
Yes, do you wish to address the court today?
Yeah, that's fine.
All right, raise, I need to be able to see you.
Yes.
Okay, can you raise your right hand for me?
Yes.
All right, do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, what would you like to tell me?
With that incident, I feel like it was just a misunderstanding. When I tried to tell the guy that came out what happened, he kind of was like, he didn't take a statement from me, honestly. I think it was more so of what my mom was just telling him. But when I tried to give him a statement, he didn't have a pen or paper or anything. He just kind of went back to his car, came back, and was and I think that was pretty much it. It wasn't, he didn't punch me in my face or anything. It was just over dramatic. How do you say that? It was just overly, it was written down incorrectly. Like my mom was just kind of being a little dramatic about the situation because of him trying to restrain me from hitting him. So he wasn't really aggressive at all.
Okay, when you say the guy that came out, are you speaking of the officer?
Yeah, the officer.
All right, are you in fear of Mr.
No.
No. You all have a child together?
Yes, we do.
How old is the child?
He's a month old.
1 month old? Okay.
Yes.
Do you all reside together?
No, we don't.
All right. Any cross-examination questions, Ms. Salette? Or Mr. Bartels?
Your Honor, just a few questions.
Okay.
Ms. Bryson, you called the police on September 26th for this case?
No, it was my mom. She was calling because she thought that like we were about to destroy her apartment, but that wasn't the case. He was just restraining me from hitting him.
And you had blood on your shirt, correct?
Yes, I have braces. So my lip was stuck caught in my wire, in the bracket of my wire and my braces. And I had to like physically pull it out.
Okay. So according to the report, your mom didn't state that she witnessed any punching, so the officer would have only been able to get that statement from you. So
No,
on that day, you told the officers that he punched you.
No, I did not. What my mom came in, she told him he was talking to her mostly. He didn't really take a statement from me when I didn't even have a phone because my phone was broken at the time. So she called them because she said that that we were in there fighting or whatever, and she thought that we were going to destroy the apartment. So when the officer came out, they called her phone to let them know that he was outside. So she went down and he got her statement. And then I came down. By the time I came down, he was I think had looked at my lip, and I think he took a picture. I can't remember if he took a picture or not. He took a picture of it, and then he was asking me if I wanted to press charges or whatever. And I said no, but then he came back and said that I guess whoever he had talked to on the phone was like that, it's out of my hands.
And you were pregnant at the time, right?
Yes.
Okay. And the defendant was not on scene when officers arrived.
I can hear you.
The defendant was not on scene when the officers arrived. He fled the scene.
Yeah, no, it was just me and my mom.
Okay. Nothing further from the state at this time, Your Honor.
All right, Mr. Martellus.
Nothing from defense, Your Honor.
All right. All right, I'm going to order the $10,000 surety bond, $5,000 on each charge. Excuse me. I'm going to order a stay away from the incident location, which is the 3787 Martin Luther King Jr. Drive, apartment B2. I'm going to order no further contact with the victim and the witness, which would be Miss Bryson and her mother. What's your mother's name?
It's Tiangela, I believe, Tiangela.
That's what I have.
Okay. Same last name?
Yes, Your Honor.
Okay, Tiangela Frison. And no drugs, alcohol, or weapons while on bond. And I think that's it. Anything else, counsel?
Nothing from defense, Your Honor.
Okay.
Nothing from the state.
All right. Thank you for your time, Ms. Bryson.
Position 3, Cameron.
Case number 22 CR 008153J, Tevin Cameron, charged with 1 count of simple assault, family violence, 2nd count of simple battery, family violence. And the offense date is July, let's see, I'm not able to see it. You show that, Miss Bridgewater? Oh, there it is. July 31st, 2022. Pre-trial.
He has a total of 11 cycles. Last arrest was January 5th, 2022 for simple battery family violence. That is an open case, 22 CR 000-074J. It is the same victim as today's case. He also appears to be on probation out of Fulton County for aggravated assault with a deadly weapon and possession of a firearm by a convicted felon. Case number is 20 SC 176579. Disposition was October of 2020. 1 year confinement, 9 years probation. He also has a 2016 aggravated assault conviction, 2009 aggravated assault and theft by taking conviction, 2008 theft by receiving stolen property conviction, 1 FTA from 2009, 5 probation violations, 2009, 2011, 2015, 16, and 2020, and nothing further.
Okay. All right,
And
she's select. Yes.
thank you, Your Honor. I just also wanted to add that when I was looking through Odyssey, I saw another aggravated assault with a deadly weapon conviction out of Fulton County, 19 SC 165943. That aggravated assault conviction has the same victim in this case, and he is on felony probation. It looks like 15 years, and is to have no contact with the victim in this case, Krishan White. On July 31st, 2022, at around 5 a.m., officers responded to 2591 Etheridge Drive, apartment B303. Upon arrival, they spoke with the victim in the case, Ms. Krishan White. Krishan is spelled Krishan. She told the police that on the previous night, she had an altercation with her ex-boyfriend, the defendant, where he had been taken to Grady Hospital by police. She stated while she was laying in her bed at around 5 a.m. on July 31st, she heard the front door being kicked in, and so she ran into her closet. While she was in her closet, the defendant confronted her, grabbed her by her left arm, and held her down and told her to look at his face. The victim was able to break free and run away and call for help. Ms. White complained of pain to her left arm, but refused medical attention on the scene. And the two were in a relationship over the past year and lived together throughout that year. Our office has had contact with the victim. She stated that she's called the police on him many times, and he keeps receiving bonds and getting out and coming back to her home. She said she's in the process of seeking a TPO and trying to break her lease at the apartment complex. She also stated that she would like for him to receive a high bond so that he's unable to get out, and that she likely would not be on the Zoom today to speak on her behalf. Due to the defendant's extremely violent felony history, he has, it looks like 5 aggravated assault convictions, 3 of them for family violence, 1 of them against the same victim. He also has an open misdemeanor case, simple battery family violence against the same victim, where he's out on a $3,500 surety bond and isn't supposed to have any contact with her. The state is going to be requesting a $20,000 cash bond. Stay away from the incident location, no contact with the victim, no alcohol, drugs, or weapons. So we would be requesting a $10,000 cash bond on each charge. The state would just argue that based on his history and him kicking in her door, that this could lead to something really violent in the future. So that is the state's request at this time, Your Honor.
All right, Mr. Bartels.
Yes, Your Honor. I did speak with Mr. Cameron. He has worked in the recent past, has worked a lot as a contractor in construction, but he indicates that he hasn't worked in that capacity for a couple months. So he would qualify for our services, but he is looking for employment and hopes to find something soon. He does have ties to the community. I'm advised that his mother and father both live in the metro Atlanta area, and that, in anticipation of a no further contact order, he indicated that he could stay with them. So that would not be an issue. He does deny the allegations that are in the warrant. We would also note that the complaining witness did not call the police until it looks like this happened early in the morning one day, and then the police were called the next day. He does have two charges, simple assault and simple battery. There's no allegation of any physical injury. I do believe, again, this is would be a duplicate charge because they're both based on the same alleged act, the same unit of prosecution. So we would ask the court to keep that in mind as well. We would ask for a $5,000 total bond, $2,500 on each charge.
Okay.
And Your Honor, I see the victim's name on the line. So Your Honor, we would ask that you would sound for her if she would like to speak when the time is appropriate.
All right. Ms. White, is it Krishan White? Krishan White. I don't see. All right, I'll move forward. I don't see her on the screen. Do you, Ms. Salette?
Yes, Your Honor, I do see her name. There she is.
It's on the screen.
There she is. Okay. Hi, good afternoon, Ms. White.
Hey, Your Honor.
Do you wish to address the court?
Yes.
All right, raise your right hand for me. I'm gonna swear you in first.
Okay. One.
Do
This
you,
right.
do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. What would you like to tell me?
Okay. Which incident we been speaking on? Because, like it was told, I have been calling so many times. It's been so many times I've called. So I don't know which incident to really speak on.
This is the simple assault on July the 31st.
Okay, with that incident, okay. Officer was called to my home. They said it was the wrong address. Okay, he took off running. I don't know why, but he took off running and he ended up messing up his face. And he said it was my fault. Like I called the police on him, which I didn't at that point. Okay, so he come. I guess when he got out of Grady, he come here kicking my door. I had took his stuff. I had done took his things to his sister and all that. So he come kicking my door. I hide in my closet. I'm trying to get away from him. I end up falling and break. My arm was this out of place. I had this going to Grady because I had my daughters and stuff. So after that, I called the officers. Officers came. They seen him. He took off running, and after that, they got my statement.
Okay. Are you in fear of Mr. Cameron?
I am.
Okay.
I wouldn't be calling the police so many times. Like, I'm really scared for even saying something now.
Okay. All right. Any cross-examination questions, Ms. Salette or Mr. Bartels?
Your Honor, thank you.
Your Honor.
All right. I am going to order a $10,000 cash bond, $5,000 on each charge. That'll be a $10,000 cash bond, $5,000 cash bond on each charge. No drugs, alcohol, or weapons while on bond. Stay away from the incident location. And I'm going to also order no further contact with the victim, Krishan White. And is there anything else, counsel, I need to take up?
Nothing from the state.
All right. All right,
Thank you.
good luck to you, Ms. White.
Position 15, Williams.
This is 22 CR 008167, Theodore Williams. charged at one count of criminal trespass, offense date December 6, 2022. Pretrial.
He has 18 cycles. Last arrest was January 18th of 2012 for criminal trespass. There's no disposition listed. 2008 probation violation. 2002 driving while license suspended or revoked conviction. 2002 theft by conversion conviction. 2002 giving false name and driving while license suspended or revoked conviction. Driving while license suspended or revoked conviction 2000. Acquiring license plate for purpose of concealing identification of a motor vehicle conviction 2000. And the rest of his 6 arrests are in the 90s, but I didn't see any more convictions.
Okay. All right.
Yes, Your Honor, this offense did occur yesterday at the location of Bedford Pines, located at 398 Parkway Drive Northeast in Atlanta. In this incident, officers responded or were dispatched to that location for a suspicious person call. When they got to that location, they were identified by the, they were told by the property management that the defendant was trespassing on the property. The property manager, Carol Cooley, is who informed officers of that. She stated that the defendant had entered the property. He was witnessed on the property, and she indicated that he had already been given a criminal trespass warning in the past about entering the property of Bedford Pines. So given that this defendant had already been told not to come back to this property on a prior occasion, according to the property management on site, and he was located on the property, the state does have some concern in this case about risk of reoffending. This defendant does have a criminal trespass arrest from 2012. The state is cognizant of the remote history. However, it does show some pattern and risk of reoffense here, given that the state is, there is a $2,500 surety bond currently set on this case. The state is amenable to reducing that to $1,000 surety bond with the conditions of stay away from the incident location of Bedford Pines, no alcohol, drugs, and weapons, and no violations of Georgia law.
All right, Ms. Kim?
Yes, Mr. Williams. He is 73 years old, Your Honor, and he has been here in Georgia all his life. And he had one son, but he passed away. So ever since then, he does not have that many family members here in Georgia. However, he dreams to meet with his grandchildren in Macon, Georgia. Before he does that, he wants to make sure that he has his life together, right? Because of his auto accident and severe leg injury from that accident, he has not been able to have any employment. Indeed, he gets Social Security checks, which is not that much. So he is qualified for public defender's service. And at this point, he has been residentially challenged. So he's trying to get PAD program with a police help so that he can start his housing and he can have his life better. They also help him to get a job. He's trying to basically, all he wanted to do was just stay away from the rain. It is just very unfortunate that it was the same location that he had a warning, which he didn't remember. And it was just kind of like an unfortunate incident. We would like to request for a signature on bond. His last criminal trespass was, Your Honor, 2012, which was 10 years ago. And he really needs to get that PAD program signed up so that way he doesn't lose his opportunity to have a housing. Thank you.
Okay. All right, then I don't think we don't have a witness on the line, do we?
No.
Okay. All right. And the state was recommending reducing the bond to $1,000 surety bond. Is that correct?
Yes, Your Honor, there's a current $2,500 surety bond that was preset. We're amenable to reducing it, taking into account the remote history. However, we still have concern about the risk of reoffense. So we're asking for that 1,000.
Okay, all right. I will enter that $1,000 surety bond. No drugs, alcohol, or weapons while on bond. And a stay away from 398, I think it was Parkway Drive Northeast, or the Bedford Pine, join to stay away from the whole complex. Is that correct?
Yes, Your Honor.
Okay. So stay away from all of Bedford Pines, Mr. Williams. You understand that?
Your Honor, he has a police alternative diversion program that is lined up. If he's not going to be able to pay for any bond with his financial resources, $1,000 coupon is more like no bond for him. If that's the case, he loses that opportunity, and it's going to make a lot more hardship. So I was wondering if you could, Your Honor, could consider one more time for signature on bond.
And respectfully, Your Honor has ruled, and we would ask the defense to respect Your Honor's ruling, given the circumstances and the all factors present. It's more than reasonable in this case.
What type of program is it, Ms. Kim?
Police alternative diversion. It's a program that provides housing and job resources, so he can make money and have a life.
Okay, well, I hope they can defer or maybe help him with this very, very low bond. I am concerned about his history and wanting to make sure that he understands that he cannot go and trespass at this location. So I will stick with the $1,000 surety bond.
Thanks, Your Honor.
All right, thank you.
Thank you.
Judge, what was the bond amount?
$1,000 surety bond.
Thank you. Position 12, Redwick. Come on, sir.
All right, this is case number 22 CR 008162H. This is Jason Redwick, charged at 1 count of DUI, driving under the influence of alcohol as safe, and a 2nd count of driving possession of open alcohol container. Offense date is December the 2nd, 2022. Pre-trial.
21 cycles, multi-state offender, has 3 arrests out of Indiana, 1 out of Tennessee, 15 out of Illinois, the last 3 are out of Georgia. The last arrest was December 12th of this, I'm sorry. Give me 1 moment. The last arrest was December 2nd of this year for disorderly conduct out of Clayton County. He has 1 FTA from 2016 out of Georgia, a theft by shoplifting conviction in Banks County out of Georgia from 2016. Has a August 4th, 2022 arrest out of Tennessee for DUI. There's no disposition listed, so that case appears to be open. Has a 2021 arrest for conviction for possession of meth out of Indiana. And then a January of 2022 FTA out of Indiana. And then out of Illinois, his last felony conviction out of Illinois was in 2004, and that was a felony conviction for armed violence and aggravated assault. And the rest of his convictions out of Illinois are in the 90s.
Yes, Your Honor, I did have that 2022, I believe Indiana operating a vehicle while intoxicated as a conviction. From what I saw, the other charges were dismissed, and that last charge was an actual conviction. In addition, I did see a 2005 operating while intoxicated an endangering person with no disposition from 2005. And I additionally saw another 2016 FTA in this case. This incident, in fact, did occur on December 2nd, 2022. Officers were dispatched to the area of Bethsaida Road and South Hills Road. Upon arrival, officers witnessed a vehicle occupied by the defendant in this case that was running and parked in the turning lane on that specified roadway. The officer said that the accused was in the passenger seat and he was breathing but unresponsive. Officers at that time did call for medical, and upon medical arrival, officers stated that they were able to wake the defendant, and the defendant began slurring and making noises, but consistently passing out. And while transporting this defendant from the vehicle to the ambulance, officers smelled the odor of alcoholic beverage on the defendant's breath. They said that the defendant's vehicle also contained one open beer can that was half full and one half empty liquor bottle on the passenger seat. In addition to this defendant's criminal history, this defendant does have a lengthy driver's history report with 1, 2, 3, 4, 5, 6, 7, 8, 9 traffic citations that range from failure to obey traffic signals, seatbelt violations, failures to maintain lanes, speeding, and operating a motor vehicle while intoxicated out of Indiana. So this is not this defendant's first driving while intoxicated type offense. He's gone to several states and done this on several occasions. So we do have a extreme concern about the risk of reoffense in this case. We do believe that this defendant is a danger to the community, given this driving history and the offenses alleged here. We do have some concerns that this defendant is a flight risk because we did see that 2016 FTA and that 2022 FTA from another state. We have concerns here, Your Honor, and this defendant does have a possible open case. Given that, the state is going to be requesting a $3,500 surety on the DUI and $250 on the open alcohol container for a total bond of $3,750, no alcohol, drugs, and weapons, and no further violations of Georgia law. We're also going to be asking for no driving, given this defendant's repeated history with issues of driving while intoxicated, including one arrest for driving while intoxicated and putting another person in danger, heightening that risk of reoffense. For those reasons, Your Honor, we think the state's recommendation is more than reasonable.
All right.
Yes, Mr. Redwig is 42 years old. He has been here in Georgia for about 14 years. He has 3 minor children, Your Honor.
PD Kim?
Yes, Your Honor.
Yeah, camera is off, I believe. Oh, there it is. Okay, I see it. No, no worries. I got it.
Okay. So he has 3 children who are 4, 11, and 14, and he has a wife. He is sole breadwinner for actually 6 family members, who includes his elderly father-in-law, who is going through dialysis right now. And because of his condition, it's a lot of expenses in terms of living expenses and medical expenses for his father-in-law, who they have to take care of. And he is the sole breadwinner at this point, Your Honor. So he is qualified for public defender's service, and he does not have much financial resources at this point. So we would like to request for the minimum possible bond amount, which is maximum $1,000 for total charges, Your Honor. He's been working as a welder for about 7 years at Design by Initiative. It's at Fairfield, Georgia. And he also has high school diploma, and he does not have anybody who can actually bond him out at this point. So we would like to request for a maximum $1,000 good bond. Thanks.
All right. I am concerned about his history and some of the other Ayala factors. I guess we're just lucky that no one's been hurt or killed here. So what I'm going to order is the $3,750 surety bond. And that'll be $2,500 on the DUI, $250 on the open container.
You mean 3,500, Your Honor?
I'm sorry, I did say the wrong thing. So I had 2,500 on the DUI and 250 on the open container. Is that correct?
Yes.
The state was recommending 35. I just wanted to clarify.
Right. Yeah. So that'll be a total of 2,750. If I check the math there. So 2,750 surety bond. I'm going to order no drugs, no alcohol, no weapons while on bond. And I'm going to order no driving while on bond at this point. So we can hope that other citizens will be safe on the road here. And so therefore, if he needs to get to work or anywhere else, once he makes bond, he can get a cab or an Uber. But I don't want him driving yet until he comes back before the court for any other dispositions on this case. All right, anything else, counsel?
Nothing further.
Nothing further from defense.
All right, thank you.
Thank
Position
you.
9, Dooley.
I'm sorry?
Position 9, Dooley.
9.
I believe they're taking a plea on position 9,
Correct.
Is it?
and I already have the paperwork.
Wonderful. This is Mr. Hughley.
Ma'am?
Are you Mr. Lloyd Hughley?
Yes.
Case number 22 CR 008156D. Are you representing yourself?
I had a lawyer.
Indicated to me that since he wanted to take a plea, it's their policy that he would proceed with the plea pro se.
I understand. Do you want to take a plea today, Mr. Hughley, to the charge of criminal trespass? I have one count of criminal trespass.
Ma'am?
Are you wanting to take a plea today to one count of criminal trespass?
Yes.
All right. Are you willing to represent yourself?
Plead guilty.
Right. The offense date is December the 6th. And are you going to be represented by an attorney?
I hope so. No.
Ms. Bridgewater, is your understanding, or I'm sorry, ASG Duncan, what's your understanding on his representation?
My understanding is that the public defender's office has a policy to not represent defendants who decide to take pleas at first appearance. This defendant did sign the paperwork, which I believe includes a waiver. So my understanding is that this defendant was going to be taking this plea pro se.
Do you understand that, Mr. Hughley? When you signed the plea paperwork they sent you, include a waiver, and you're agreeing to represent yourself. The personal public defender's office is not going to be representing you if you take that plea today.
Yes, ma'am.
Is that your understanding?
Yes, ma'am.
So then you're taking the plea without representation, with no attorney?
Yes, ma'am.
And that's what you want to do?
Yes, ma'am.
And when you represent yourself, you're to know the rules of evidence in court and know what you're doing.
Yes.
Okay. Well, I'm gonna go through some steps here before I can accept and take your plea. And just want to make sure that you understand what you're doing. First, I need to inform you that you do have a right to remain silent. And anything that You state regarding the facts and circumstances of your case could be used against you. But since we're going to take the plea, I still want to remind you of that, okay?
Yes.
All right. And you are willing to go forward without an attorney.
Yes.
And I'm going to place you under oath. Raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And again, state what is your recommendation for the plea?
State's recommendation in this case, Your Honor, is 12 months probation. Serve 1 day, credit for time served 1 day, stay away from the incident location, which is the BP gas station located at 1450 Donnelly Avenue Southwest. A brief factual basis for the state's recommendation is that on December 6th, 2022, officers were dispatched to that BP gas station when they spoke with the store manager, Dennis Osuwu, OWUSU, and he indicated that he told the defendant in this case to leave the store. However, the defendant refused. And when officers arrived on site, the defendant was still standing outside of the property near the front door. Officers went out at that time and told the defendant to leave. They indicated that he did leave for a few minutes. However, he returned about 4 minutes later to the property and was then taken into custody.
All right. And so with the 12 months probation, credit for time served 1 day, and to stay away from the BP gas station at 1450 Donald Lee Hollowell Avenue, or Donald, did you say Donald Lee Hollowell Avenue?
No, Donnelly Avenue.
Donald Lee Avenue, okay, Donnelly.
Yes,
Gotcha.
And that is balance suspended?
correct.
Okay.
All right. And there's no further contact or anything like that, is it?
No, there's no further contact. We just want to stay away from that location.
All right. All right, so Mr. Hughley, do you understand the plea that the state has just read? Are the conditions?
Yes.
Okay, so that's 12 months probation, credit for time served 1 day. Balance is suspended of that probation, and you are to stay away during that 12 months from the BP at 1450 Donnelly Avenue Southwest. Can you do that?
Yes.
Okay. All right. So I'm going to get ready to take your plea, and I'm going to ask you a series of questions. And the first one being, are you wishing to plead guilty today to 1 count of criminal trespass?
Yes.
And are you under the influence of any medication, drugs, or alcohol at this time?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
Oh, I'm sorry, you don't have an attorney. Are you satisfied that you are going to represent yourself sufficiently?
Yes.
You understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you're prepared today to waive these rights, is that correct?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And as to the charge of criminal trespass, how do you plead? Guilty. All right. So I just want to make sure you understand you're on 12 months probation, but the balance is going to be suspended, and you need to stay away for the next 12 months from this BP at 1450 Donnelly Avenue. All right.
All right.
All right. I'll accept your plea and good luck to you.
Thank you.
Okay.
Position 7, Dyer.
Okay. This is case number 22 CR 008159C, Philip Dyer. You're charged with one count of willful obstruction of a law enforcement officer, second count of obstructing the highway, street, sidewalk, or other public passages, and a third count of pedestrian in the roadway, all with the offense date of December 6, 2022. Pretrial.
45 cycles, 16 out of Georgia, 29 out of Illinois. Last arrest was November 24th, 2021 for a probation violation. He appears to be on probation out of Fulton County for simple assault and disorderly conduct. 21 CR 006-900C. The disposition was December 9th, 2021, 12 months probation. He has a 2019 theft by shoplifting conviction with Fulton County State Court. 2009 terroristic threats conviction out of Gwinnett County. A 2007 forgery conviction out of Gwinnett County. A 2010 willful obstruction of a law enforcement officer and criminal trespass conviction out of DeKalb County. He also appears to be on probation for terroristic threats. 19 SC 172434. The disposition was April of 2020. It was 4 years probation. Along with that terroristic threats was a criminal trespass conviction. He also had a simple battery conviction from 2019. And out of Illinois, he has a few convictions, with the last conviction out of Illinois being in 2005 for criminal trespass, and then a 2000 criminal damage to property and resisting officer, an ag assault in 94, and those are out of Illinois.
Okay. All right, ASG Select.
Yes, Your Honor. On December 6, 2022, officers Atlanta Police Department noticed that the defendant was in the middle of the intersection of P Road and Sidney Marcus Boulevard, in the middle of the roadway, obstructing traffic and asking passing motorists for money when they drove by. Officer Strutt approached the defendant and identified himself as a police officer with the city of Atlanta, the defendant for identification. The male stated that he had a voter card and that he had lost his state issued ID card. Officer Strutt then asked the defendant to place his hand behind his back in order to detain him. The defendant stated that he was not going to follow the officer's instructions. He stated that he was not going to put his effing hands behind his back and that he wasn't going to do anything the officer asked. At this point, two other officers were helping Officer Strutt try to detain the defendant, but he continued to resist. Additional units were called out and they were finally able to detain the defendant. The defendant was taken back to the Zone 2 main precinct, and after running his GCIC, they noticed that he did have a warrant out of Fulton County for probation violations for terroristic threats and criminal trespass. Due to the defendant's history, the state would argue that he poses a risk of reoffending while out on bond. He's currently on misdemeanor probation. He has a history of obstruction, simple battery, criminal trespass, and theft. The state would be asking for $1,000 surety bond on each charge. No alcohol, drugs, or weapons. Stay away from the intersection of Piedmont Road and Sidney Marcus Boulevard in Atlanta. Nothing further from the state at this time.
All right, Mr. Bartels.
Yes, thank you, Your Honor. I have spoken to Mr. Dyer and looked into this case. I would note, well, I understand that he was approached by the police allegedly because he was in the roadway. Just in looking at the warrant, and I know this goes beyond a probable cause issue, but I would note that it doesn't appear the officers had a legal justification for trying to handcuff him, and his alleged refusal to be handcuffed apparently is the basis of the obstruction charge. If they did have authority to conduct an investigative stop. There's nothing in the paperwork I have that indicates that he was acting in a dangerous manner or that he possibly had weapons on him. So, I don't know why they believe they could handcuff him just to do an investigation. And again, that's the basis of the obstruction. Or the obstruction of the law enforcement officer. I know he's charged with obstructing a highway and pedestrian. Those would seem to be. Ask the court to keep that in mind.
I think I lost you. Yeah.
Yeah, we would. Okay, the obstruction highway and the pedestrian charge appears. So I would say that they're duplicate charges. We would ask the court to keep that in mind for bond. I would ask for, in light of what I've said, I would ask for a $500 bond on the second charge and a signature bond on the other two, based on all of that. Although realistically, he's likely not going to be able to bond out, but that's what I would ask for.
And you were kind of going in and out on me. I heard about the pedestrian in the roadway. Tell me your bond recommendations again.
Yeah, my position was number 2 and 3 would be duplicate charges. Number 1, I don't believe that the officer, based on what's here, had justification for trying to handcuff him. So based on that, I would ask for a $500 bond on the second charge and ask the court to consider signature bond on number 1 and 3.
And Your Honor, the basis for officers attempting to detain the defendant is for him being in the middle of a busy roadway, obstructing traffic. And then when asked for identification, he didn't have any identification. So at that point, officers did have a basis to arrest him, number 1, and number 2, try to identify him. Nothing further from the state.
Well, I would just respond, that he wasn't under arrest at that point. They said that they tried to handcuff him in order to detain him. I understand that they can try to determine someone's identification, but unless you're driving, you're not required to carry an ID on you. So nothing further.
Okay. Well, some of those arguments would be later in the case as opposed to me determining bond at this point. Due to the high number of cycles and a multi-state offender, I'm going to do a split bond. And on the split bond, I'm going to do for the first charge of willful obstruction, that's $1,000 good bond. On the second charge of obstructing the highways, that will be a $500 bond, surety bond, or good bond. So that's $1,500 good bond for the first 2 charges. And the third charge of pedestrian in the roadway, I will do a $500 signature bond through the jail. Got it, Ms. Bridgewater? Did I say it clear?
You did.
Okay.
Making it a total $2,000 split bond.
Yes.
Mm-hmm.
1,500 surety, 500 signature. Yep. All right. And obviously no drugs, alcohol, or weapons while on bond. And I think the state did request a stay away from Piedmont Road and Sidney Marcus Boulevard, that area.
The intersection, Your Honor.
The intersection. Okay. All right, and I will order that.
Particularly the middle of that.
I'm sorry.
It's particularly the middle of that intersection. He understands.
Position 6, drawn.
Okay. (22 CR 008157D), Darnell, drawn. You're charged with 1 count of battery 2 counts of battery, family violence, 3rd count of cruelty to children in the 3rd degree, 4th count of willful obstruction of a law enforcement officer, and a 5th count of cruelty to children in the 3rd degree, all with the offense date of December the 6th, 2022. Pretrial.
He has one prior cycle from October 27th of this year out of DeKalb County for theft by receiving stolen property, and that case appears to be open.
Okay. All right, ASG Select.
Yes, Your Honor. On December 6, 2022, Officer Jay Jones was dispatched to 4979 Old National Highway. Upon arrival, he came in contact with one of the victims in this case, Miss Valeria Drawn. That's Valeria Drawn, Draughn. She's the sister of the defendant. And Ms. Drawn advised that she was involved in a verbal dispute with her brother, the defendant. Ms. Drawn stated that the verbal dispute escalated and the defendant began to punch her in the face. While on scene, there was a 13-year-old juvenile with the initials AR. She tried to stop the defendant from punching Ms. Drawn. And at that time, the defendant began to start punching her as well. So both victims did advise that the defendant punched both of them in the face. Officers did observe bruising on both of the victims' faces. And this assault also occurred in the presence of a 2-year-old with the initials JD. All parties live in this household, and that 2-year-old is Ms. Drawn's daughter, so that is not the defendant's child. We have had contact with the victim in this case. I'm not sure if she is on the Zoom or not at this time, but she did state to us that she would not like to have contact with the defendant. And he does live at that location with him, so she wasn't sure if she could request for him not to come back, but she did not like to have contact at this time. Due to the family violence nature of these charges and how the defendant could influence witnesses based on them all being related, the state's at this time is going to be a $13,000 surety bond in total, a $5,000 surety bond on each battery charge, and a $1,000 surety bond on each additional charge. Nothing further from the state at this time.
All right.
I am also in the Zoom meeting.
I'm sorry.
I am in the Zoom meeting.
Oh, okay, Miss Drawn.
Ms. Drawn.
Okay, all right. Let's see, whose case is this from the PD?
That is my case, Your Honor.
Okay. You
I
want
have
to
spoken.
before or after the witness?
I can let the witness speak first.
Okay, all right, Ms. Drawn, you wish to address the court?
Yes.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, what would you like to tell me?
I would like to tell you that I believe that everyone is in danger of him. He's a very violent person. When he doesn't have his way, even if you don't say anything to him and ignore him, he still escalates his own self, and then he gets physically violent when things don't go his way. He's psychologically abusive to people around him, and I just feel like he does not even deserve a bond because he's abusive to other people, and he's a man. And I also would like to add, he didn't punch my sister in the face intentionally. He punched her, but in the back of her head, because she was trying to break him up, and I am pregnant, and that's why she intervened.
Okay. All right, are you in fear of him?
Yes, I am in fear of him.
All right. And who resides at this location, the 4979 on National? I think it said all parties reside there.
Yes,
Okay.
but I'm rarely there unless my sister needs me or my mother.
Mm-hmm. Okay. And the defendant resides there as well, is that correct?
That's correct.
All right. Hold for a second, mute yourself. Let me hear from Mr. Bartels.
Yeah, give me just 1 second, Your Honor, if I could consult.
Okay.
Yes, Your Honor, I do have a few questions.
Okay.
Can you hear me okay?
You're going in and out. I think we'll get the gist of it. Let's see.
Ms. Drawn, can you hear me okay?
Yes, I can hear you okay.
My name is Paul Bartels. I'm with the public. I am representing Mr. Drawn. You had indicated other incidents involving him. To your knowledge, has he been arrested for anything else involving you or any other members of the family?
No, he has not been arrested for anything involving anyone else, but the police have been called on him previously for other acts against family members or violent acts around children.
But none of those resulted in an arrest.
None of them resulted in an arrest.
Now, you also said at this location, I'm a little confused. You said that, well, we heard that you and your other siblings live there, but you also said you're rarely there. Do you have something?
So I'm rarely there because I work a lot. That's why I'm rarely there.
To your knowledge, if he could not stay at that household, does he have it?
Yes, he does. He has a friend who would willingly let him stay, and he's not a threat to her. She doesn't feel as though he's a threat to her. So I know she'll be willing to let him in her household.
Is that Miss Harriet by any chance?
That is Miss Shari Harriet.
Sorry, Harriet. Okay, yeah, because I did talk with her on the phone. That's who I thought you were referring to.
Yes.
To your knowledge, does he have a job or any income coming in?
He has no income, and he chooses not to have an income.
All right, I don't have any further questions, Your Honor.
All right. Any questions, Ms. Salette, of the witness?
No questions from the state, Your Honor.
Okay.
Yes, Your Honor. But can I go, or is this?
Oh, yes. Go ahead. Go ahead and present, Mr.
Yes, Judge. We would ask the court to consider a signature.
You went out on me.
I've got a new laptop. It's apparently works well for everything except Zoom calls. We would ask the court to consider a signature bond. He is 17 years old. I'm seeing date of birth of December 15th, 2004. The only previous arrest we're hearing is a theft charge in DeKalb. I did check on that. He was in jail for that from, I think, October 27th to the end of November. Aside from that, I'm not aware of any other arrests. So his history is minimal. It does appear that he has some other place to stay. I'm advised, well, up until the point where he was arrested in DeKalb County in October, I'm advised that he was attending Towers High School and that he's a junior's there. Towers High School, Towers. That's in Belvedere in DeKalb County in Georgia. His mother, I'm advised his godmother, is Harriet as well, live in the area. So based on all that and his minimal history, we would ask the court to consider a signature bond. Ms. Harriet did advise me that she would be willing to be an adult co-signer, and she believes that his mother would as well.
And Your Honor, the state would just ask that you listen to the pleas of the victim in this case. Although he does have minimal history, he is 18 years old. So that could be
Well, not yet. He's 17 now.
Oh, well, Your Honor, he's only 17 years old. So I just wanted to just add that in as well for your analysis. Thank you, Your Honor.
All right. Well, he's still in high school. Is that correct? He's not working.
That's what I'm told.
Ms. Drawn?
Yes.
Yes. Is the defendant, is he 17 and not working, or what do you understand and know of his status?
He's 17, he's not working, he's currently not in school, he refuses to go to school. And when he is in school, he leaves early. And he's currently unenrolled because he was in jail during the time, and they asked my mom when would he get out, and they tried to work with him throughout the school year, but his behavior and his attendance got in the way of him being unenrolled. Was a factor of him being unenrolled.
Okay. Has he always gone to that high school?
Yes, I believe he's always went to Towers High School.
But right now he's unenrolled. Do you know if he can go back or not?
I'm pretty sure that the principal up there, she will be willing to let him come back, as well as the assistant principal.
Mm-hmm.
As long as they're able to come to an understanding with my mom, Latoya Mitchell.
Right. Your mom's name is what again?
Latoya Mitchell. That is Latoya Mitchell, Mittchell.
And then your godmother is it Shari Harriet?
No, Shari Harriet is my child's grandmother. So she has no relations with me. That would be his godmother.
Yeah. Okay. No relation to you, your brother's godmother.
Yes.
Okay. Okay. What I would like to do with this matter is to because there's several charges here. I want to give a signature bond through the jail. And let me see the amounts. On the first charge with the battery, it's $2,000 on the battery. Family violence, so that would be $2,000 on each, which is $4,000. Cruelty to children, $500. Willful obstruction, $500, and then the other cruelty, $500. So that's my 5 charges. So that totals $5,500. Is that correct, Ms. Bridgewater?
Yes, ma'am, it is.
Okay. So a $5,500 signature bond through the jail. And the breakdown again is $2,000 on each of the batteries and $500 on each of the other 2 cruelties and the obstruction, for a total of $5,500. And the co-signer, and you tell us, Mr. Bartels, which one it's going to be, because they like to put that in the order.
Well, I directly spoke with Ms. Harriet, Your Honor, so I would put her.
Okay.
I wasn't able to reach Ms. Mitchell.
Okay.
And that's Shari, Chari. And Harriet is Herriott.
All right. So that he's not held up, just in case, Ms. Bridgewater, let's put, or we will accept his mom, Latoya Mitchell, either one, just so that he's not held up.
Okay.
And also, Mr. Drawn, I want you to get back in school or get your GED. All right. Because you're almost in. Are you on track to graduate?
No, you just go on.
Can't hear you. But I want you, your sister says possibly you could get back in if you're going to follow the rules and go to school. So either get back in school or go get into a GED program.
She don't need work. She just sit down at the house all day. Then she go to every Thursday she go see her boyfriend and leave her child.
Sir, I would advise you not to say anything else at this point.
Now, I'm not liking what you're saying because that's not the person under the spotlight. You're under the spotlight. And you're only 17. And in another year, you should be graduating from high school on your own, getting a job, or going to college, one of the two. So we want to make sure that you are going to be a productive citizen in society.
I want y'all to.
I want you, huh? Don't interrupt me, but I want you to focus on yourself and making yourself a better person. So should I not let you out on a signature bond?
Yeah.
Okay, are you going to go to school or check into a GED program, one of the two?
Yeah.
Okay, so you need to get yourself together and work on you. Otherwise, you're going to be right back down here, and next judge may not be that happy with you and may not be giving you and may not be able to give you any grace. But we don't want you to get into this criminal situation, no matter what, okay?
All right.
I want you to work on you. So no drugs, alcohol, or weapons while you're on bond, none of those, except for something prescribed to you by a doctor. All right, take care. Good luck to you.
Is there a stay away?
Hold on. Yes, I'm sorry. There is a stay away. Thank you. Stay away from 4979 Old National Highway. And I understand that you do have somewhere else that you could go live while you're on bond or stay with someone else. But I don't want you to go back to the house, okay? All right, get yourself back in school, get an education.
I'll follow up with that, Your Honor.
All right, thank you. I appreciate
And
that.
what was his mother's first name again?
Latoya.
Latoya. Okay, got it.
Mitchell, yeah.
Latoya.
Yes, thank you.
All
Do you
right.
have the no contact with the other victims?
I'm sorry.
Do you have the no contact with the other victims?
And I
Valeria.
apologize. Yes.
The
And
minor,
Valeria Drum
right.
and Asia Ricks.
yeah, she's a minor, AR and JD.
Gotcha.
Okay.
Yes, and Your Honor, I just have to say for the record that the state is objecting to the signature bond through the jail. The defendant was just arrested in October of this year for theft by receiving and was released in November and has already picked up a new charge where he's actually being violent towards people. It's escalating from a theft to violence towards family members. So the state just wanted to put on for the record that we are objecting to the signature bond through the jail. Thank you.
All right, thank you. So noted.
I'm sorry, Judge, the whole bond was a signature bond through the jail? Was it a split bond?
No, whole signature bond through the jail.
Okay, thank you.
All right.
Judge, next we have, this is our last case, position 15, Mr. Snyder.
Okay.
Oh, Your Honor.
All right, this is case number 22 CR 008166D, Justin Snyder. You're charged at one count of DUI, driving under the influence of alcohol as safe, driving improper erratic lane change, and a third count of driving on expired or no license plate or decal, all with the offense date of 11/10/2022. Pre-trial.
3 cycles. Last arrest was August 25th of this year for giving false name to law enforcement officer. That's an open case, 22 CR 005703S. He has no convictions.
You recommend it?
No.
Okay. All right. ASG Duncan.
Yes, Your Honor, this incident did occur on October 10th, 2022 in the area of Woodstock Road. Officers were observing traffic in the area near the LA Fitness when they noticed a Cadillac being driven with a passenger side headlight out, traveling on that road. They began to follow that vehicle and they positioned themselves behind that vehicle in an attempt to make a traffic stop. But while they were about to make the traffic stop, they noticed that this car was changing lanes multiple times. At that time, they did initiate their emergency equipment and make a traffic stop. Upon making contact with the driver of the vehicle, who was identified as the defendant in this case, they told him the reason for the stop. They immediately observed that the defendant's head, face, and hands were covered in blood. The officers observed that the defendant was bleeding heavily from his head and asked what had happened to him. He stated that he was involved in a physical altercation at a friend's house. Officers indicated that the vehicle that the defendant was driving displayed heavy damage on the front side of the vehicle. The windshield wiper displayed a spiderweb crack. The back seats were out of position and leaning forward in the vehicle, and the vehicle showed signs, according to officers, of having been in a recent accident or collision. Upon making further contact and communication with the driver and defendant in this case, they indicated that the defendant had an odor of alcoholic beverage emanating from his person. They observed that his speech was slurred and that he had red and watery eyes. While they were waiting for the ambulance to arrive, they did speak with the defendant in this case. He indicated at that time that he had been coming from a party and that he had 3 beers. At that time, the defendant indicated continued slurred speech and lack of awareness about the current situation or the lack of the severity of the situation that he was in, according to the officers. The officers also indicated that the defendant was having trouble standing in one spot after being asked to get out of the vehicle. He was swaying back and forth. Once the emergency medical services arrived, they were able to check him out, and officers did locate 2 empty bottles of liquor, 1 whiskey and 1 vodka in the vehicle. The defendant was transported to North Fulton Hospital, and the officer relocated to North Fulton Hospital with the defendant. And then further talking about the incident, the defendant recanted his original statement and told officers that he had 2 beers. At that time, the officers read the defendant implied consent, which he refused. And based on the officer's evaluation of the situation and the factors as I've listed, and the officer's experience and training, they felt that this defendant was impaired to the extent that it was less safe for him to drive at the time. He was left at North Fulton Hospital because his injuries needed clearance. And I believe after he was cleared by the medical staff, he was let go, and I think picked up later on this warrant. His driver's history does only indicate this refusal of implied consent. So what that usually means is that the defendant driver's license is or will be suspended for refusal of implied consent. In this case, Your Honor, given the severity of the circumstances and the factors alleged, we believe that this defendant may be somewhat of a danger to the citizens of Fulton County, given the nature of driving on the road, and a danger to himself, given the severity of the injuries alleged at the time of interaction with the police officers. For those reasons, the state is going to be requesting a $3,500 total surety bond. That's $3,000 on the DUI and $250 for the improper or erratic lane change and $250 for the driving with expired or no license of decal. I would also like to add that officers did indicate that the decal on the car that was being driven by the defendant did expire sometime in 2021. For those reasons, we think that $3,500 surety is more than reasonable. We'd ask for no alcohol, drugs, and weapons, no further violations of Georgia law, and no driving, since it is likely that this defendant refuse implied consent and their license will likely be suspended in that administrative proceeding. Nothing further.
All right. PD Kim?
Yes, Your Honor. Mr. Justin Snyder is 28 years old, and he has been here in Georgia all his life. He does not have any children. He's a single. However, his family members are all here in Georgia. He has been working at a restaurant as a bartender and server for about 1 year. And Your Honor, since he's not going to be qualified for public defender's service, therefore my representation will be ending at the end of this bond hearing. He's residing at his sister's place right now, and he graduated from high school, and we would like to request for the minimum surety bond for $1,000, and also hopefully those driving violation will be a signature bond through jail, so that way we can have a split bond so that he can get out of the jail and continuously work for his jobs. Thank you very much.
All right, I'm going to order the split bond. And what I will do is on the DUI, a $2,000 surety bond. And then on the other two driving offenses, $500 each signature bond through the jail. So we've got $1,000 signature bond through the jail, $2,000 surety bond on the DUI. So that's the split total of $3,000. Is that right?
Yes.
Yeah. Always have people check my math.
All right, Judge, I have a quick announcement for position 2 is going to be a medical reset, and we're completed here in courtroom 2, Judge.
All right, thank you.
What are the other conditions for position 15 besides the split bond?
Oh, I'm sorry. The other conditions, yes. No driving. Looks like with an expired tag and probably doesn't have a license anyway. So let's add on the conditions of no driving. No drugs, alcohol, or weapons while on bond. And I don't think you asked for any stay away or anything, did you?
No, Your Honor.
Okay, just those other two conditions, no driving and no drugs, alcohol, or weapons while on bond.
Yes.
Your Honor, if he gets a valid permit and tax from DDS, can he drive, right? It's just no driving unless he has a valid license and tax. Did I understand?
I'll clarify that, yes, from DDS.
Yes, thank you.
And it's my understanding, just for the record, that if a defendant in a DUI case refuses implied consent, that their license will be suspended. So it's unlikely that he will get that valid license, but I appreciate the court's clarification.
Okay, thank you.
Thank you.
And not on this case, Your Honor, but for position number 2, where the announcement was a medical reset, I just wanted to note that I believe this defendant was arrested on December 4th on Sunday, and he's been reset a few times. So I just wanted to note that that hasn't been due to any fault of the state, and that the defense may want to consider getting a waiver. But I just want to put that on the record.
Well, the good thing is he keeps coming up on the calendar. We reset him for that, so there shouldn't be an issue for that. But if the defense can try to get a waiver, that would certainly.
We attempted to speak to him today, but that did not come to fruition.
Okay.
I think if we have another appearance, and still not able, then I think we need to probably order some kind of evaluation.
All right. Thank you for that, ASG Select.
Okay, so Your Honor, are we ready to go over the calendar?
Yes, ma'am.
Okay, with that being said, once again, the reset date for the SAP calendar is December the 20th, Position number 1 is going to the SAP calendar with a $10,000 total good bond. Again, position number 2 is medically reset till tomorrow. Position 3 is going to the SAP calendar with a $10,000 total cash only bond. Position 4 SAP calendar with a $6,000 total good bond. Position 5 reset to the SAP calendar with a $2,000 good bond. Position 6 is reset further notice with a total $5,500 SOB through the jail. Position 7 SAP calendar with a $2,000 total split bond. Position 8 is going to the SAP calendar with a $15,000 total good bond. Position 9 took a plea. Position 10 is reset further notice with a $1,500 SOB through pretrial. Position 11 is going to the SAP calendar with a $2,000 good bond. Position 12 is going to the SAP calendar with a total $2,750 good bond. Position 13 is going to the SAP calendar with a total $1,750 good bond. Position 14 is going to the SAP calendar with a total $8,000 good bond. Position 15 is going to the SAP calendar with a total $3,000 split bond. And position 16 is going to the SAP calendar with a $1,000 good bond. Are there any questions, comments, or otherwise?
Yes, ma'am. I just had one question on number. I thought I heard you say $6,000 good bond.
I can't hear you. What position was that?
Number 6, Mr.
Position
Darnell.
number 6. Okay, position. No, I have a $5,500 total SOB through the jail.
Okay, got it.
Okay.
All right, thank you.
You're welcome. Are there any others? If not, okay.
All right. Thank you, everyone.
Okay, see everybody tomorrow.
Thank you, Janice.
All right. Okay.
All right.